Well, yesterday we learned that the 11th Circuit Court of Appeals ruled against Orlando Food Not Bombs and in favor of the City of Orlando in the lawsuit over this food sharing in public parks that has been going on for just about 5 years, actually. The basis of the decision was not what we expected. There was a little twist to it that at least I didn't exactly see coming. The last time we went up to Atlanta to argue in front of the court, the issue was limited to whether sharing food with hungry and homeless people in a public space like this is expressive conduct protected by the First Amendment. That it sends a message to the community that there's a problem with hunger and homelessness and we're not doing a good job. The court accepted that this food sharing is protected First Amendment activity, that it's free speech, and that there is a message to the community. But the court found that the city's ordinance is a reasonable restriction on this activity. And that's kind of basic First Amendment law. You know, back to you can't yell fire in a crowded theater. The court relied a lot on a case called Clark, which was about some demonstrators who wanted to sleep in Lafayette Park, the park which is right across the street from the White House in Washington, D.C. And I think an important difference between that case that the court relied on so heavily and this situation here, sleeping and camping are not generally allowed in Lafayette Park. It's a little urban park with like benches and that's it. There's no facilities, there's no bathrooms, camping isn't generally allowed, so those demonstrators were seeking to do something special that wasn't generally permitted. But in our case, we're talking about people eating at picnic tables and people who just want to be able to do what everybody else can do. Between the fact that you can get permits, there are 40 or 42, we never really got a straight answer, parks within the 2-mile radius of City Hall that can be used on a rotating basis, and there's like 60 more parks beyond 2 miles from City Hall that can be used, that there are other ways for Food Not Bombs and the other groups that are using the park to convey their message to the community, to tell this community that there's a problem with hunger and homelessness and we're not doing a good enough job. First Amendment law, you can't be completely cut off from your intended audience. And way back at the beginning of this case, when the city opened Sylvia Lane, which is an abandoned parking lot, it's over that way, abandoned parking lot, chain link fence, no bathrooms until we complained enough that they finally brought some porta potties, barbed wire on the fence, up against the train tracks. Nobody could see them at all, out of sight, out of mind, I guess. That would cut this off from their audience pretty much completely. Instead, the court yesterday said, well, there's other parks you can use, there's other locations, you can get a permit, and you can use, that there are other options, that you're not being completely cut off from your intended audience. As far as the discussion of hunger and homelessness in our community and what we should be doing, that discussion is certainly not over. In terms of where this particular event goes in the future, we don't know yet. There are some options that need to be explored, and Food Not Bombs and some of the other interested folks will be getting together to talk through all of that and make a decision.